News just coming in. President John Dramani Mahama has suspended the Chief Justice Gertrude Torkonoo following the determination of a Prima Facie Case against her in the 3 petitions submitted to the president seeking her removal. We have details for you right now in relation as the president also sets up a 5-member committee to investigate the set details in the petition. I am here with my colleague Joseph Akable, but we'll be getting into the details as to this breaking news that's coming through right now, Joseph.
Well, big news coming out now. We know that this is something that a lot of people have been looking forward to. Questions have been asked. At what stage are we in terms of this particular process? We know that the petitions were sent to the president. We know that the matter is in court. An aspect of it is in court. All those are issues that we had discussions over. You recall the back and forth over whether the president can't proceed with a consultation despite the fact that there was a pending motion seeking injunction. That matter is back in court on May 6th. What we'll be doing at this point in time is to break down all of these matters to you, to let it make sense to you. But the main point being that the Chief Justice has been suspended by the president. And
perhaps we'll start off with that statement that's coming through from the quarters of the presidency this hour in relation to that suspension. Joseph, you have a copy of that. If you could just start off with a verbatim reading of really what the president is saying in this particular address to the nation.
So the statement is titled, President Mahama suspends Chief Justice after setting up committee to probe petitions. President John Dramani Mahama has, in accordance with Article 1466 of the Constitution and in consultation with the Council of State, determined that the Prima Facie Case has been established in respect of 3 petitions against the Chief Justice, Her Ladyship, Justice Gertrude Torkonoo. The President has consequently established a committee in compliance with Article 1466 of the Constitution and in consultation with the Council of State with the following composition to inquire into the petitions which have been referred to them. So in terms of the membership of this particular committee, 1 is Justice Gabriel Scott Palmine, who is a Justice of the Supreme Court, who will be acting as chairperson of this committee. Justice Samuel Kwame Adibu Esiedu is also a Justice of the Supreme Court. Then there is Daniel Yao Domelevo, you know him, a former Auditor General here in Ghana, and Major Flora Bazwanura Dalugu of the Ghana Armed Forces, and Professor James Sefa Jisa, an associate professor at the University of Ghana. So pursuant to Article 14610 of the Constitution, in accordance with the advice of the Council of State, the President has by a warrant suspended the Chief Justice with immediate effect pending the outcome of the committee's proceedings. And this statement is signed by Felix Kwaku Annan, the spokesperson to the President and Minister in charge of Government Communications.
And we see a number of things immediately detailed in this statement that's come from the President. One having to do with the provisions on the processes in removing the Chief Justice. The President has exercised that right to suspend the Chief Justice pending investigations by this 5-member committee. Now we've seen the composition of the committee as well, and has been rightly articulated in the Constitution. 2 members from the Supreme Court, and then 3 others who are not lawyers as well and are not members of the Council of State, all rightfully listed. Per what we're seeing, the supposition is that Justice Gabriel Palmine will chair this particular committee, which will be looking into the matters in these 3 petitions which have gone before the president, and we now have a determination that there's a prima facie case that's been brought against it. I want to just, from the start, again, perhaps walk viewers through where we've come from up until this point, that a prima facie determination has come through from the president, and then we'll be crisscrossing different parts of the country as well, and then perhaps lean into the arguments that have been made to and fro as to really what happens from here on in. And so, viewers, stay with us as we try and start the entire process again from the 25th of March. That's where Felix Kwaku Annan released that statement detailing that 3 petitions had been submitted to the president, and the president has forwarded same to the Council of State pending consultations with them for a determination as to whether or not a prima facie case can be brought against the Chief Justice, or whether or not she has a case to answer. The essence of that entire Latin word prima facie is whether or not the Chief Justice, per these 3 petitions, had a case to answer involving these 3 petitions. And from there, we know that suits were filed against the ongoing processes, questioning whether or not the president had afforded the Chief Justice the opportunity to be heard. In fact, on that 27th, there were two suits we know which were filed in relation to this particular matter. And on that same day, we saw the Chief Justice writing to the president asking for copies of the petition upon which she was expected to be given a right of fair hearing, an argument she made quite succinctly in that write-up to the president. On the following day, the 28th, the president wrote back to the Chief Justice, including the three petitions, while expressing disappointment. Is worthy of note that the letter from the Chief Justice on the 27th had leaked to the media even before it got to his quarters, but nonetheless wrote back to her and gave her 10 days upon which she was supposed to respond to these three petitions. And then we know as well that while the Chief Justice was writing to the president in relation to her official responses, the suits which were seeking to injunct the entire process were also expected to be tabled before the Supreme Court. On the first day where the injunction applications were expected to be heard, on the 9th of April, the suits were not heard because the Attorney General had written to the Supreme Court asking that they be granted some leave because there was a seminar of some sort which was happening between state attorneys. Godfred Dame Joseph,
he expressed serious concerns about the fact that he does not understand why such a matter that is being dealt of this nature, especially because he says there's a deputy attorney general who he makes the argument it's not a state attorney, so one of them could have been dispatched to handle that particular case. And you recall again that it was at that engagement that I had with him that he had made a point that as far as he's concerned, he thinks that the president cannot proceed with a consultation with the Council of State
pending suits.
Because of the pending suits that are outstanding. Until those ones are dealt with, as far as he was concerned, the case has to be on hold. The consultations have to be suspended for the matter to be dealt with.
But that did not stop the Chief Justice, we understand, in subsequent days in submitting her official response to the president as well. And so after that happened, we proceeded to the 16th, which was the next agenda date for that particular suit, seeking to injunct the ongoing process which has reached this particular stage where a committee, a 5-member committee, has been formed. On that day as well, we know that they could not sit because a justice expected to be on the panel was not present.
In fact, it was the same day that we heard for the first time from the Attorney General speaking directly to this process. Now, the Attorney General takes a different view to what Godfred Addo had taken. Dr. Dominic Ayine told us that as far as he's concerned, the president's role, interaction with the Council of State in terms of determining whether on face value there's a case that a committee ought to be set up to look into, is a constitutional duty.
Right.
And he says nothing enables any court to interfere with the president exercising that constitutional duty. And so when we asked him directly what he makes of the position that had been advanced by Godfred Addo, he made the point that as far as he's concerned, nothing stops the president from undertaking that consultation. We know that they are supposed to go back to court on May 6th, but we know that the president has gone ahead to exercise the constitutional duty. As his Attorney General had indicated, he was not going to be stopped by any court, or no law allows any court to stop him from doing so, which is exactly what the president has done today.
And you're raising already the first of many questions which Ghanaians are going to be asking. What happens to that May 6th sitting where the injunction application was supposed to be heard, and whether or not the court was going to be able to injunct what the Attorney General described as a constitutionally mandated process which required the president to go through. Let's try right now and get responses quickly from Martin Pebu, who's a private legal practitioner, on the latest that we're getting from the quarters of the president. Counsel, appreciate that you could speak to us this afternoon. The latest coming from the quarters of the president, first ever, we're having a Chief Justice suspended pending a determination of this 5-member committee whether or not she will stay in office. Are you surprised by how all of this has played out up until this point?
I'll say yes and no. Surprised to a certain extent, but also not surprised. So let's say the truth of the matter is that as soon as some of the information surrounding this case leaked on social media, and looking at that, then it began to show that, hey, something like this could happen today, because some of the rules are a bit strict. I mean, I don't want to go into the specifics because the committee is now going to go into the matter. But what the point I'm making is that we all have seen certain things on social media, and some of those rules are strict. You see, the painful side of it is that, yes, the figures may be small, but it's the same rule. You know how in Ghana, and I'm not prejudging, I've not mentioned what I've seen, but I'm just giving an example. You know how we talk about when somebody steals a goat, he gets convicted quickly, blah, blah, blah. So the point I'm making is that, yes, it's true that some of the things we've seen on social media, they may look like they look small, the figures look small, etc. But unfortunately, it's the same rule, whether the thing is 1 Ghana cedis or 200 million Ghana cedis. So based on certain things that I saw on social media, the surprise element went away because the way those things were looking around, though, and thankfully, look, and to be very clear, it's not a petition I've seen. I've not seen any of the petitions, but we saw this excerpts of some audit reports, etc. And, you know, when you see sections, you look at the language, you try to, you know, look at the grammar, syntax, all those things, context, to find out whether this thing looks genuine or it's fake. And some of them looked genuine. And since then, it's not been rebutted. And even the MPP also, oh yeah, I left out the main point. The MPP in their press conference also gave some information that showed that they are seen some of these things. So when you put everything together, actually the surprise element, it's been gone for some days now.
Let's talk about the integrity of the process, part of which you've been speaking to about portions of these petitions and the conversations which have surrounded it up until this point. Would you say that based on what it is we've seen up until this point, the integrity of this entire process up until this determination by the Council of State in consultation, or the President in consultation with the Council of State in determining there's a prima facie case, that process has been safeguarded, would you say?
Absolutely, Martin. Absolutely. Look, listen, you know, I want to say something that 10 years from today, I will be able to say the same thing. I think so far the process, the integrity has been safeguarded. You remember, I mentioned that what we saw, at least from what I saw, and which is going around on this in social media, is an excerpt, or let's say excerpts of audit reports, not a part of the petition. I'm telling you for a fact that I haven't cited the petition.
Right.
And looking at, yes, so meaning that it's been safeguarded, because if a lawyer, at least somebody like me, interested in public interest, etc., the petition hasn't leaked to me, it tells you that the process is been safeguarded. It's been safeguarded. Right. So all I'm saying is that based on the report, that those excerpts, and then based on what the MPP revealed at their press conference, where they sought to cast insinuation, and already saying the next Chief Justice will be a party sympathizer of the MPP, those unsavory things, that is what took away the element of surprise for me.
There are a number of questions that spring up off the top of my head in relation to the process now that we're getting into this 5-member committee. Even before a determination of a prima facie case could have been made, there was this heated debate as to whether or not the Chief Justice had a right to be heard in determining whether or not a prima facie case has been formed or has come up against her. She's provided her response. There are many who ask the question, wherein lies the rest of the process, where she's already provided her written responses to these allegations, and yet a determination has been made that there's a case for her to answer. Wherein lies the fact that she can't come out of this hole?
Yeah, so Martin, it's the nature of the process. That's the design. That's the way it's been designed. That, you see, let's repeat. The prima facie doesn't mean she's liable. It doesn't mean she's liable, or less in this context, for effective communication. Let's the word guilty from criminal law. We are speaking ordinary English, so I'm not tied down by strict legal rules. So it doesn't mean she's guilty, but it's not a criminal case, but we can use the word guilty. It doesn't mean she's guilty. It just means that the allegations seem to be, if she doesn't give a proper answer, it can go against her. That's the meaning. In other words, the allegations are not frivolous. They've not been made up, but rather there are certain things that exist. And so now we need to go in further, because remember that you see, the allegations are on paper. She gave her response on paper. Okay, paper to paper. Now we need to go before the committee. You come and swear before the committee. You see, it's going to be examination. You see, they are going to do an inquiry. Even though we know people can lie on oath, etc., but they are going to a court proper. All I'm trying to say, one word is that come and repeat these things on oath. Look at your Bible and come and repeat these things. Look at you, come and take your Quran and repeat these things. You're a traditional worshipper. Okay, come and affirm and tell us that these things are true. So it's when you come and swear and say they are true. You, for now, let's leave out the fact that people can lie. Let's leave that out for now. There is still that solemnity that if you can hold your Bible, promise that you say the truth and say it, then it gives it greater weight. Then they will ask you questions. So we want to solemnize the things. We want to come and repeat them on oath. Then they become weighty. You know how Ghanaians don't joke with our religion. As to how we practice, it's a question for another day. So when we do that and the answers remain the same, nothing changes, then it can go against her that, okay, then you are guilty.
Right, Counsel, Mawena here, and I just want to ask one question before I bring in my colleague Joseph as well, who's here with me. That's in relation to the ongoing court processes, the injunction application, which had been adjourned to May 6th, and then the entirety of the application, which was seeking to have the Supreme Court now finally proclaim a direct way through which this entire process of the removal of the Chief Justice can go through. What happens first off to the injunction application now that we've seen the president reach this determination, and then the substantive case as well?
It means effectively the injunction application becomes smooth. I mean, I'm speaking practically. You see, I don't want to do legal. If we do too much legal, we will lose the public. Practically, once the president has gone ahead with the committee, now the Supreme Court will be slow from their own decisions in the past. Let's all remember the E-levy one. E-levy, even when, Oliver Bakavoma filed for contempt, the case was pending before the court, yet GRA and Akufo Addo went ahead and started collecting the E-levy where they promised millions of jobs. That never turned out to be true anyway. They went ahead. There are countless other cases that we can show. So what happens is that there is a rule. So in law, you hear, to every rule, there is an exception. To every rule, there is an exception. So generally, when it comes to the performance of public functions like this, then the court is slow to grant an injunction to stop the performance of a public function. The committee that has been set up, they are going to perform a public function. The work that the President and the Council of State have done, they are public functions. They are in Article 146 of the Constitution. So the courts are slow to do that. And you see, this same thing we are talking about, don't also forget, the law works in a certain context. Look, trust me, another petition, let's say, go into our future, a petition can happen tomorrow, and based on the public reaction, a president can stop. So let's know that sometimes it's not pure law, but it's also an amalgam, a totality of our reactions as citizens. The thing, if enough citizens had gotten up and started demonstrating that, President Mahama, please stop, let's finish the court case, yes, it would have happened. But once you don't have enough, because remember, and there's basis for it.
Right.
Because under Article 125 of our Constitution, it says that justice emanates from the people. So at every point in time, when the president is acting, and even the judges, etc., they also look at what the people think. So if the country was up in arms, saying that no, President Mahama, please wait, he would have waited. Right. I'm telling you, enough numbers. So it's not strict. Sometimes it depends on the reaction of society as well.
Right. Counsel, Blake comes in here right now, Joseph.
Yeah, Marina, thanks. And sorry for calling you Martin.
Sure. But Counsel, just hold for us. Let's try and just get viewers to understand, those who are joining us right now, what the breaking news is. And that breaking news is that President John Dramani Mahama has suspended the Chief Justice Gertrude Torkonoo and subsequently formed a 5-member committee which is to investigate her for 3 petitions seeking her removal after the Council of State, along with the President, determined that there was indeed cases for her to answer in relation to these 3 petitions. We're going to run you through the membership of that 5-member committee again, and then we'll go back to Council for a bit more in relation to what it is that we're seeing. And so that's what's on your screen right now, the 5-member committee, which has been set or formed by the President, Justice Gabriel Scott Poaman, who is the chairman of the committee. Also, Justice Samuel Kwabena Dibu Esiedu is a member. Daniel Yao Domelevo is a former Auditor General. The first 2 are justices of the Supreme Court. Then there is Major Flora Bazwanura Dalugu. Is an ordinary Ghanaian or a member of the Ghana Armed Forces. Remember that the provision of Article 146, amongst many other things, says that they must not be lawyers or members of the Council of State, amongst many other things. And then Professor James Sefa Jisa is an associate professor at the University of Ghana. Joseph, you want to just talk to us about these members as well, these 5 that we're seeing?
I mean, Justice Gabriel Scott Poaman is the 2nd most senior Supreme Court judge. In terms of the current composition of the court, it's only Justice Paul Bafuboni, who was appointed to the Supreme Court in 2008, who is senior to him. He joined the Supreme Court in 2015. He joined under controversial circumstances because with the appointment itself, there was a whole court case that was initiated by the Ghana Bar Association. They had raised questions about issues relating to whether the president is allowed to appoint in accordance with the recommendation that comes from the Judicial Council, the list. When they do 1 to 10, can he pick around any part of the list, or is required to start in accordance with the list? He has to start from 1. If he's picking 5, he picks 1 to 5.
Right.
And so that is how come he was one of the 2 judges who were appointed at the time. The other was Justice Agyapong, who has long retired, and so Justice Gabriel Poaman is still at the Supreme Court. He has gone on to deliver very interesting decisions over the period. Some of the decisions that have extended the frontiers in terms of the legal dispensation.
Right.
One that really comes to mind is the case of the ex-party's Senate case, the Republic versus the former Senate boss, the Director General, who was being prosecuted for the OBS software system. In that judgment, he discusses extensively issues surrounding administrative justice, judicial review. If you're asking the court to take a second look at the decision of an administrative body, what standards do you have to meet? It's one decision that, interestingly, the Chief Justice, who has been suspended, wrote the lead opinion. Justice Gabriel Poaman, who was on the panel as well, wrote the concurring opinion, and he discusses extensively judicial review in the Ghanaian context and how he thinks is different from the common law provision. Justice Samuel Kwame Adibu Esiedu is also another senior Supreme Court judge as well. He was appointed to the Supreme Court by President Akufo Addo. When he was at the Court for Appeal, he was also sitting as an additional High Court judge, and he was handling the trial involving the former MPP NDC chairman Samuel Ofosu. He was the one handling that case before we know that case was terminated eventually by the Attorney General. So that was also one matter that he did. Interestingly, and it's one of the questions that I'll be putting to Counsel when we get back to him. Justice Samuel Kwame Adibu Esiedu is on the panel hearing the injunction case in the Vincent as a full matter. The injunction against the process. He's participating in that particular proceedings. In terms of his judgments, he also has given some very interesting judgments at the court. One of them has to do with the issue surrounding if a law is repealed and you are being prosecuted, what happens? Can the trial go on or not? For those who are familiar with the law, Edmond Addo versus Attorney General is the case that he wrote the lead opinion on. Very interesting decision in there. So he's a very senior Supreme Court judge at the Supreme Court who is also participating in this one. I'll end with Daniel Yao Domelevo, the former Auditor General. You know him, most recently he was part of the Operation Recover All Loot team, a team that Counsel on the line was also a member of that particular team. We know that he was Auditor General. He was one of the individuals who was appointed just before John Mahama exited office in his first term, together with the Shrag boss Joseph Whittal. When he was appointed, we know that in the course of his work, he was asked to proceed on leave, and effectively by the time he came back, in fact, he never came back. He eventually ended up retiring.
Yeah, someone else had.
The matter ended up at the Supreme Court in the case of the CDD versus the Attorney General, and the Supreme Court took the view that the president asking him to proceed on leave and his subsequent removal from office was unconstitutional. And so that is how he left office as the Auditor General. But he's one, we know him as an anti-corruption crusader quite closely. And counsel made reference to an aspect of this particular matter that has come up. The screenshot that we see in the public domain, we don't know whether it's in the petition or not.
Having to do with audit-related matters.
Audit-related matters. And so that is another thing that has come up.
Perhaps why there could be a decision to lean in on him when there are audit-related matters in these alleged screenshots that we've seen, none of which we can substantiate.
Yes. But it's consistent with the constitutional provision in that the majority for this particular committee relative to the Chief Justice, they are not supposed to be lawyers or members of Parliament. They are not supposed to form. If you compare to the other justices of the Superior Court, the 3 are from the legal fraternity. So this time around is the 3 from the other individuals. Right. And the question first I want to put to counsel, and you did indicate that we want to make things very simple for the ordinary Ghanaian. They ask, who is the Chief Justice of Ghana as we speak? The statement is silent on that, but we know that in terms of the convention, if the Chief Justice is not around, the senior most judge acts in his stead. In this case, Justice Paul Bafo-Boni. Is it your understanding that with the statement being silent on that, he, as of now, should be the acting Chief Justice?
Absolutely, Akable. Absolutely. There's a specific provision for it in the Constitution. It's in there. I don't really have it here, but it's patently written that in the absence of the Chief Justice, the most senior Justice of the Supreme Court takes over. So it means that effectively, Justice Paul Bafo-Boni is acting Chief Justice. There can be no two ways about that.
I mean, the second question to you, counsel, has to do with the case that is ongoing in court. Justice Kwame Addo, who is on that particular panel, the injunction aspect of it, he is to form a part of this particular committee. I mean, if you were a party in the case, would you be comfortable with him remaining on the panel, or you think that ordinarily there should be some steps, maybe he himself recusing himself from it, given that they are being asked to determine first whether the president should have been restrained? That's now you've made a point that it's moot. Then the substantive issues of whether a fair hearing should be given before the prima facie determination is taking place. He's participating in that particular case.
Okay, so looking at it, it's possible maybe my answer will change, but for now, on the face of it, what we usually use to determine is whether he sat on the case. Yes, so you can be empaneled. But if you haven't had the opportunity to attend the hearing, generally, in our Ghanaian context, people will not raise our eyebrows. But from what you are saying, I get you. But, you know, sometimes this is Ghana, I mean, it's the state of our thinking. You see, in every society, it's not everything we're able to copy exactly from the white man. Ours, because everybody knows somebody, and you will find that even in Supreme Court decisions, you see the Salah case, etc.
Right.
When it comes to recusal, we are a bit different. So the main thing the average lawyer will tell you is that he didn't sit on the case. He didn't like come into open court and the case called and he had arguments. You see, but it doesn't mean that you don't have a point.
Counsel, hold on for us briefly. We've been joined by the Minister for Government Communications, Felix Kwakye, on the telephone lines right now. He authored that statement, which has become the subject of conversation. Many thanks for joining us this afternoon. How soon did the President, in consultation with the Council of State, reach this determination that a prima facie case can or has been found against the Chief Justice? Hello, Mr. Kwakye, can you hear us? Hello, Felix. Well, it does appear we don't have him. But Counsel was making the point about the recusals and how not so frequent of a development it is in this part of the country?
In fact, generally the conversation centers around issues of suspicion of bias and the real likelihood of bias, which was the point he was making, that Ghana generally we tilt towards the real likelihood of bias, and the courts have over the period. In fact, we saw it happen in some of the cases. The most recent one had to do with the case relative to the declaration of some seats in Parliament as vacant.
Right.
When the matter went to court, you know that lawyers for the Speaker of Parliament did raise issues about two of the judges that they wanted recused. I mean, the court quickly went on recess, came back and took the view that once the judges have been appropriately appointed in accordance with the Constitution, it is presumed that they can act in a fair manner.
Right, let's go back on the telephone lines with Felix Kwaku. Mr. Kwaku, so many thanks for speaking to us. Curious on the minds of a lot of Ghanaians, when the president, in consultation with the Council of State, reached this decision that the Chief Justice had a case to answer based on these 3 petitions.
Please speak up. I can barely hear you.
I'm asking when between Thursday and today, when the president, in consultation with the Council of State, reached the conclusion that indeed the Chief Justice had a case to answer?
Well, I'm not able to disclose details of the process. As you yourself may know, there are strict rules of confidentiality. But I can tell you that such a conclusion has been reached, and it is on the basis of that the president has taken a step that I have just announced.
And so, amongst many other things, one question that's being asked is, this statement you issued is silent on who takes over now that the president has suspended the Chief Justice. What's the expectation of the president?
Well, the judiciary is a well-established institution in our country. They have their own administrative processes for getting someone to act in the stead of the Chief Justice in the event that she is temporarily unavailable. That is not a matter that the president determines. It is for the judiciary to make their own arrangements.
First ever of such a decision we've seen happen under any republic outside of the first ever president the country had when he removed the Chief Justice. What sort of processes went through this arrival at this decision? Because many are curious as to why we're seeing this happen for the first time and under John Mahama.
Well, the processes are clearly outlined in Article 146 of the 1992 Constitution. Indeed, you only have to read the statement I put out to appreciate the steps that have been taken. You recall that some weeks back, I informed the nation on behalf of the president that he has received petitions from 3 different courts alleging various forms of wrongdoing against the Chief Justice and demanding her removal from office. Upon receipt of that, and in strict conformity with the dictates of the Constitution, Prez Mahama began a consultation process with the Council of State, which consultation process required that he, in consultation with the Council of State, determine whether there was any basis to proceed, i.e., determine whether there was prima facie warranting any further steps as prescribed by the Constitution. So you recall that he forwarded the petition to the Chief Justice in consultation with the Council of State and requested her to provide responses in order to enable an assessment as to whether or not some prima facie exists on the face of the petition. This was complied with by the Chief Justice, and the President continued the consultation process with the Council of State. And the outcome of that consultation was that prima facie has been determined in respect of all 3 petitions. This also then means that Article 146 of the Constitution must kick in, which then requires the President, in consultation once again with the Council of State, to set up a 5-member committee whose composition is contained in the statement I just issued. That membership of the committee is such that 2 of the members must be justices of the Supreme Court,
right?
One of whom will chair the committee, and 3 other individuals who are neither lawyers nor members of the Council of State. And so you find that the 3 others who have been named meet this criteria. They are not lawyers, they are also not members of the Council of State. Once that is done, the petitions will then have to be referred to the committee to inquire into as to whether or not there's a basis to remove the Chief Justice from office. Now, while the committee does its work and once it has been set up, Article 146(10) of the Constitution empowers the President to suspend the Chief Justice for the duration of the work of the committee up until such time that they make recommendations to the President on what further step to take. So you find that everything the President has done has been grounded in the Constitution, Article 146, and its various provisions. So if you ask me about the process, this is exactly what has transpired since the pendency of these petitions.
All well and good, these processes you've outlined, but one criticism which is coming strongly from the quarters of the opposition NPP is that you're abusing these laid down processes in Article 146, and what we've seen happen up until this point is an attack on the country's judiciary.
Well, first of all, the NPP itself has come in for criticism for their unwarranted politicization of this particular issue. It is curious that it is a political party, the New Patriotic Party, that appears to be up in arms about this. Otherwise, every reasonable person understands exactly what is happening. That the President is required to act in specific ways once he received this petition. In fact, before Prez Mahama took office, in the dying embers of the Akufo Addo administration, a similar petition went to the President, and he took the same steps that the President has taken, except, of course, the determination of a Prima Facie. President Akufo Addo also went into some consultation with the Council of State to determine whether there was Prima Facie in that petition. He, on that occasion, said there was no basis to proceed further. President Mahama, on this occasion, believes that in consultation with the Council of State, Prima Facie has been determined. So it is not clear why the NPP believes that when they are in power, their President can act in accordance with the Constitution. But when they leave power, another party that comes to power cannot act in accordance with the Constitution. So one has to question the sincerity that they bring to this whole discourse and question whether or not it is not politically motivated. Because quite frankly, they have not covered themselves in glory in this particular matter. They have needlessly politicized this and created an impression that the Chief Justice is one of them and she's been handed. And it is manifestly unfair to the Chief Justice what the MPP is doing. Their claims also do not hold merit because they cannot point to a single infraction on the part of the President in this whole process. And I'm not sure why they continue on the tangent that they are going. What has simply happened, and I must stress, that the President has not said that the Chief Justice is guilty of any offense. The President has only said that when he consulted with the Council of State and looked into the petitions and weighed them against the Chief Justice's responses, it became clear that there are further questions that need some answers. The platform to do that is spelled out clearly by the Constitution, and the President has followed that particular stipulation to ensure that the matter is determined conclusively, but it is determined by persons who are clothed with the mandate to do so, which is the committee that he has set up. So, again, I must express my surprise about the conduct of the New Patriotic Party in this instance. One can only infer political motives to what they are doing.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.